Hi, I'm Jeff Mandell, co-chair of Stafford Rosenbaum's Appellate Practice Group. This is the third of 4 videos about the U.S. Supreme Court's oral argument earlier this week in the case of Murr versus Wisconsin. In the first video, I laid out the facts of the case and how we got to the U.S. Supreme Court. In the second video, I explained the relevant legal principles that govern, that set out the law on takings claims prior to this case. And in this video, I want to talk about the arguments that were made by each of the parties to the court this week. 4 lawyers presented argument before the court. The first lawyer represented the Murrs, and he said to the court that there could be a very simple, straightforward argument to define the relevant parcel in a takings case. For the Murrs, the property is defined by the lot lines, and they really want it to end there. They say that the 2 lots at issue here had separate lot lines. Therefore, the relevant parcel, the one that they're talking about being regulated, is the undeveloped lot, and that is the property and the only property the court should be looking at. After the Murrs, the state of Wisconsin presented its argument. The state also seeks a simple, bright-line test to define the property interest at issue. But the state does not agree that lot lines are the correct bright-line test. For the state, the issue is looking at state law as a whole. In this case, because state law provides that the Murrs' 2 adjacent properties, neither of which is large enough to be developed on its own, and they are under common ownership, because state law says that they merge into one property, the state says that is the proper analysis, and that's the proper property to be considering for the takings here. The third lawyer represented St. Croix County. St. Croix County disagrees with both the Murrs and the state that this can be done through a simple bright-line test. St. Croix County favors a multi-factor test to decide and define the parcel at issue. And St. Croix County suggests that that test should include the economic impact of the parcel, the reasonable expectations based on state and local law, and the physical and geographical characteristics of the parcel. The final argument was presented by a lawyer for the United States government. The United States got involved in this case as an amicus, or a friend of the court, supporting the position of the state and county that there was no taking here. Like St. Croix County, the federal government thinks that there should be a multi-factor test, but the federal government seems to want that test to be even broader than St. Croix County suggests, saying it should include those factors necessary on a case-by-case instance to serve the interests of fairness and justice. On top of all this, several additional parties filed amicus briefs but did not get to present oral argument. Among those are 18 other states who fall on both sides of the case. Some are for the Murrs, some are for the state of Wisconsin, and Stafford Rosenbaum filed an amicus brief supporting the state and county here on behalf of 3 major municipal organizations in the state of Wisconsin: the Wisconsin Counties Association, the Wisconsin Towns Association, and the League of Wisconsin Municipalities. In the fourth and last of our videos, I'll talk about what happened at oral argument and what we expect to happen from here.